Mr. Henry, fentanyl is a very dangerous drug. So you need to make a decision on what you want to do with the rest of your life. Otherwise, only two options for you, prison, or you may end up being on the news, body found on the side of the street or something. This case,
There are none.
right. Mr. Henry, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented? I'm going to show you what's entitled Court Admonish.
We don't renew the habitual offender allegation. I'm sorry, Judge.
That's okay. Any objections to the waiver?
None, Your Honor.
Judge, we are proceeding under count 1 and waiving count 2. So a couple of changes there. Sorry.
All right, any objections to those waivers?
None, Your Honor.
So for purposes of the record, the state is waiving count 2 and the enhancement paragraphs. Is that correct?
That is correct.
All right. Mr. Henry, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with prohibited substance in a correctional detention juvenile facility?
Yes, ma'am.
That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
All right, off the record for a moment. So can everyone please make sure you're whispering? It's difficult to hear. Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Mr. Henry, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 3 years in the prison. The state will take in consideration night bag number 722901, county court cause number 713591. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
None, Your Honor.
Then to count 1 in the indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Your Honor, I offer State's Exhibit 1 in the attachments.
Without objection, Judge.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor. We waive any pre-sentence investigation.
Anything you wish to say on behalf of your client?
Just asking the court to follow the deal. If the court's disinclined to do so, I can make some further arguments.
All right. Court will follow your agreement, sentence you to 3 years in the prison. Take in consideration night bag number 722901, county court cause number 713591. Give you credit for any time served. Would you like to be placed in the, well, considered for placement in the therapeutic community? Okay. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Henry, fentanyl is a very dangerous drug. So you need to make a decision on what you want to do with the rest of your life. Otherwise, only two options for you: prison, or you may end up being on the news, body found on the side of the street or something. You understand?
Yes, ma'am.
All right, good luck to you, okay?
Thank you.
17 seconds into sentencing, Judge Boyd doesn't sugarcoat it. Lewis Henry just pled guilty to sneaking fentanyl into a juvenile facility. The deal, 3 years in prison and 1 brutal warning: your only future is prison or a body on the side of the road. If fentanyl had you this deep, what would you choose? Keep using or fight your way out? Tell me in the comments. And don't forget to like and share for more real courtroom moments.
Mr. Hunt,
And are you Mr. Hunt?
Yes, ma'am.
We're hearing a motion to set bond. State, have you had a chance to review the motion?
We have, Your Honor.
State, are you ready to proceed?
Yes, Your Honor.
Defense, do you have any witnesses?
No, Your Honor, I've conferred and we have a proposed agreement. I'd like to present it before
All right, what is your proposed agreement?
$15,000.
All right, so I need to know something about this case.
Well, Your Honor, was on a $10,000 bond. There was, I believe, an allegation of a violation of protective order. The court remanded with that bond. He was not in custody at the time. He was on bond.
Okay.
He was later picked up on the remand. Now, as I was conferring, it seems that nothing has transpired on that alleged violation of protective order. Hasn't been filed. I'm still seeking some police reports to sort of verify it. But as from what I can tell, nothing has happened on that. But he still has no bond. So conferring with the state, they agreed $15,000 to be approved.
Okay.
And Your Honor, just like counsel stated, so we were able to show counsel some of the, again, it has not been filed, some of the misdemeanor police reports for the video allegation wherein defendant called twice. And then again, as alleged, to have shown up to the house, but then when the complainant opened up the door, he was running away.
All right, who is the alleged complainant?
It is, name, Your Honor, is Brandy Hall. That's Brandy spelled B-R-A-N.
All right, I just have a few questions to ask your client, and this as it relates to whatever conditions of bond that I'm planning to place on him. Mr. Hunt, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, state your name for the record.
Keith Hunt.
All right, Mr. Hunt, if I were to follow this agreement that has been reached, who would you be living with?
My grandparents.
All right, and have you spoken to your grandparents?
Yes, Your Honor.
And do they want you to live with them?
Yes, Your Honor.
Have you asked them, may you reside with them?
Yes, Your Honor.
All right, and is that location anywhere near the complainant?
No, Your Honor.
The other thing, are there any drug issues with you in the past or present?
No, ma'am.
Have you ever used any marijuana or anything of that nature?
I've used marijuana
How long ago has that been?
in high school.
Right, any other drug?
No, ma'am.
Alcohol issues?
No, ma'am.
And are you employed?
Yes, ma'am. I did have a job, but I don't know if I still have it now, but
Okay.
I was working with CCC contractors. I have a CDL. I drive end-up trucks.
Okay. All right, any mental health issues? Ever been diagnosed or taken any type of mental health medication? All right, anything else?
Just to tell the court, I did speak to his grandparents and I would verify that he can live with them. They want him out and they're very supportive.
All right, and is the complainant aware of this?
The complainant is aware that it's on the docket, but not of any potential resolution, Your Honor.
All right, and has the complainant been cooperative?
It's a yes and no, Your Honor. they have fluctuated between their cooperativeness with the DA's office.
All right, so I'm gonna grant the agreement, but there's to be no contact with the complainant. Do you understand?
Yes, ma'am.
That means no phone calls, no going to their home. I don't care if you all say you're trying to work it out. Nobody's ready to do counseling for you all at this point in time, so there's to be no contact. If you have any contact with her, what's going to end up happening, if it's proven, you're potentially looking at having your case heard while you're in custody. Do you understand?
Yes, ma'am.
So there's to be no contact with Brandy Hall. Do your grandparents have a landline or cell phone? What is it?
Cell phone?
Do they have a landline?
No, ma'am.
Are you sure? Usually grandparents have a landline. How old are your
My
grandparents?
grandparents are 75, but they're tech savvy.
I have a landline. Usually everybody has, my mom has a landline.
I don't have.
You don't have a landline? Yes, you all will be regretting that if you've seen some of the sci-fi movies we've
I know.
seen.
It goes down, we're all.
All right, do you want GPS?
The state was referred, Your Honor, yes.
The only problem is unless it's changed, I think GPS may need a landline.
Is it potentially possible to make that request? And then if that ends up being the case, it would just not be a condition fulfilled, or?
Well, I don't know if you all want to contact the complainant and see what the issue is as far as fear, not fear. I'll order the GPS, but if there's an issue, counsel, where he can't receive the GPS because he doesn't have a landline, have they changed that probation? He's not on probation. So I think they still require a landline. What I can do in exchange for the landline, since he doesn't have a landline, he will be with, I think he's with pretrial services.
Mhm.
I'll make him report to them weekly.
Your Honor, that would be perfect. Thank
That'd
you.
be fine.
Okay.
All right.
All right, report to pretrial services weekly. And that will be until further notice. All right, where are we on discovery on this case? I think we're coming back on January 30th.
That's it.
All right, is there anything else?
Nothing further.
All right, thank you.
Thank you.
Just 1 second, Ms. Ferguson, if you'll give him a resets form for January 30th in case he's released.
Oh,
All right, thank you.
thank you.
Thank you again, Your Honor.
Thanks.
Has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Lawrence, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 7 years in the prison, and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes, Your Honor.
Did you also understand if the court finds that there was a deadly weapon involved, there will be an affirmative finding of deadly weapon? I'm sorry?
Yes, ma'am.
Okay. Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Your Honor, I offer State's Exhibit 1 as attachment. No objection, Judge.
Mr. Lawrence, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. and states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Out of this transaction, he was also charged with a federal crime for felon in possession of a weapon, of a firearm. He was sentenced in that case, and we just asked that you follow this agreement and run it concurrent with this federal case. I do not have the federal case number, but we just asked that you run it concurrent.
All right.
Judge.
Yes.
Daniel S. Clark with the state of Texas. I had spoken with defense counsel. I did want to bring to the court's attention, there had been a subpoena issued by defense to Windcrest regarding any type of records on the complaining witnesses involved in this case. I didn't have anything responsive. I hadn't requested anything. I don't think Windcrest has responded to defense, but that's something that also could be out there.
We did speak with Windcrest. I did speak with Windcrest city attorney, and they were going to be filing a motion to quash, but we never really got to that point. We're willing to go forward, and I'm aware of that there was possibly some other information out there, but I don't believe it regards or is relating to this particular case.
All right. All right, then the court will find you guilty, sentence you to 7 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon, and this is run concurrent with the federal case number. If you're able to provide the court with that number, we can include it in the judgment.
Yes, Judge.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, sir.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll speak to an attorney. You understand?
Yes, sir.
All right, we can go off the record. How old are you?
26.
All right, you're 26 years old. You're living fast. If you come back to a court in Texas for another felony case, depending on what the felony is, your minimum sentence is going to start at 25 years. You understand?
Yes.
And I will tell you from experience, once you reach past the age of 21 years, just start flying by. All right? Okay, good luck to you.
Thank you.
Thank you, Judge.
Discovery acknowledgement page does acknowledge the discovery in the case.
All right, the court will find that the state is in compliance with discovery. Mr. Rowe, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you applying for deferred adjudication in this case?
No, Your Honor, it's probation.
All right.
We'd love to defer it though, if the court would consider it.
All right, Mr. Rowe, I'm going to show you what's entitled True Bill of Indictment. Let me find that here. Did you review that document with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are.
Going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes,
Sure. Just one moment. Did you understand you're charged with the offense of driving while intoxicated, third or more? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a factual as well as a rational understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Rowe, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes,
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 5 years in the prison. There's a $600 fine. Is the state in favor of community supervision?
Yes, ma'am.
It's not just checked. That's probation. They're saying they want the judge to give you probation on record. This is an official record. It's not changed. Yeah, that's what I was saying. Yeah, and I should have got it too, so it's okay.
No problem. All right, state is recommending community supervision. DWI intervention course, PAM for half the term of probation, VIP panel in 2 years, driver's license suspension. All right, so what I can tell the parties is I am not going to go along with PAM unless he provides an affidavit of non-driving.
We understand that, Your Honor.
So if you all want to not put this as a part of your all agreement and put it below the line, and what I will do is I'm willing, if he doesn't have a vehicle
Yeah.
or there's not a vehicle at his house, then I'm willing to do Pam for half the term, but there has to be an affidavit of non-driving, and I must know that there's no vehicle at his home or residence.
So what she's trying to say is that any vehicles at your home, if there's only one truck in the driveway, it's your wife's, your mom's, your dad's, that vehicle will be equipped with ignition interlock.
That's right, I understand that. Additional. What was he doing? Was on bail? Didn't he have both or something?
We were gonna get both, but he got locked out of a work truck and he had a lot of issues with that device and the fees on it. So he's had problems with it before.
Okay. So below the line, Judge?
Yes, so if y'all will remove Pam for half the term and just put Pam below the line. And just so you know, if I follow your plea bargain agreement, I'm going to order that you have ignition interlock for half the term if you have access to a vehicle. If you do not have access to a vehicle, which means there's no vehicle in your driveway
That's correct.
or parked on the side of the street, if you don't have access to a vehicle and you provide the court with an affidavit of non-driving, then I'll allow for Pam.
Okay.
But only under those circumstances.
And that's even if other members of the home provide affidavits that they won't let him drive it still.
We'll cross that bridge when we come to it. I don't cross the bridge until it's built.
Yeah, I mean, there's vehicles down here too. There's no vehicle for progress on this.
Thank you.
With probation for you.
All right. So according to the plea bargain agreement, there should be DWI intervention course. VIP panel, 2-year driver's license suspension. Did you understand that to be the plea?
That's correct. ma'am.
Defense,
Yes, Your Honor.
state?
Yes, sir.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in both places?
Right.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
Just discovery motions, Your Honor. There have been no other filed motions.
All right. Outside the agreement, state is requesting that your community supervision be for a term of 5 years. There be a TAP evaluation, GPS in lieu of Bear County Jail sanction, portable alcohol monitoring for half the term of probation. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Your Honor, in lieu of the GPS would actually get credit for the time served. He's done many more days than 10 in Bear County Jail.
All right. Did you understand those were recommendations and the court does not have to follow those recommendations? Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Your Honor, I offer State's Exhibit 1 in the attachments.
Any objection?
Oh, Your Honor.
I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Yes or no?
Yes, ma'am.
Right. Again, because you've entered this plea bargain agreement, did you understand that the state will be offering evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes,
Anything you wish to say on behalf of your client?
Your Honor, he's been in custody now several different times. I know at this point in time, he's expressed a great deal of remorse. He had some issues with his ignition interlock and some other problems early on. A lot of that was related to finances. I would say pretty much all of it was related to finances. That is from trouble that he's gotten himself in. But he's shown a lot of remorse for a situation. He understands that this 5 years probation requires him to not drink alcohol at all. And I do think he's going to abide by that. And that's the reason why he decided to make this decision today. As the court will note, I was not supposed to be pleading this client today. I was going to be withdrawing, but this is what he wanted to do. We were able to go over everything, and that's what he wanted to proceed with today. So I'm helping him do that.
All right. So are you employed?
Not the time.
When's the last time you were employed?
Since the last time I got in custody.
All right, and what were you doing?
The 4th of December,
And what were you doing?
all filming.
And is that what you're going to continue to do?
That's correct. I've been doing that for the past 13 years.
All right. How long have you been in custody? Since December 4th?
Yes, that's correct.
All right. Obviously, you have an alcohol problem. Probation, how long would it take to do a TAP evaluation in custody?
Approximately 2 weeks.
And how long would it take out of custody?
That's going to be a couple months.
All right. This is what the court will do. The court is going to find you guilty, sentence you to 5 years in the prison, suspended and probated for 5 years. DWI intervention course. DWI education, victim impact live. 2 years driver's license suspension. Ignition interlock for half the term, or the court will allow Pam with an affidavit of non-driving and plus proof of no access to vehicles. There's to be regular reporting by Zoom or in person. There's to be regular UAs, a referral to felony drug court. We're going to do the TAP evaluation while in custody. If the TAP does not take place in 2 weeks, let the court know and I'll release him.
Sure.
There is 10 days in the Bear County Jail as a condition of probation. The court will show that as satisfied. 180 hours of community service restitution. Do you have any children? Do you have any children?
Yes, ma'am.
What are their ages?
20, 15, 12, and 9.
All right, parenting classes. Field visits. One time per month. For 3 months. And then at probation's discretion. Probation, is there anything else? Yes, if he completes parenting classes, then the community service hours will be deemed satisfied. Yes, because that will be quicker actually than TAP. So the TAP evaluation and felony drug court is in custody. All right, is there anything else? Yes. Yes, proof of employment. Within 45 days of release. There's to be no employment as a home healthcare provider or with minors. All right, Mr. Roa, is there anything else you need from the court? All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. If there are any issues, talk to probation. If you feel as though probation is not addressing those issues, let the court know. Obviously, you have an alcohol problem. You're probably one of those people who can't drink alcohol at all. Nobody ever intends to go to a restaurant or go somewhere, drink, get intoxicated and kill somebody, but it happens every day. So don't be that person where you're stumbling out of a vehicle and the person you hit is dead. You understand? All right, good luck to you.
Thank you.
At 1 a.m. in Texas, this man stood in court on his third DWI, staring down a possible 10-year prison sentence. Instead, the judge gave him 5 years of harsh probation, ignition interlock or alcohol monitor, drug court, community service, and then warned, next time, it's prison or a body on the side of the road. Was this mercy or a mistake waiting to happen? Hit like, share this clip, and tell me what you think in the comments.
Judge, I did want to let the court know that I saw him yesterday for a while and he seemed very sick. Today, he seems worse. I was concerned, and I am wearing a mask because both of my parents are having health issues of their own, and I certainly don't want to risk getting infected, but I asked if he had requested or been given a COVID test, because it seems that there's a lot of people that are sick in the area where he's being kept in the jail, and he said no. But I don't know if you're able to ask if he could be tested, but it certainly would give me peace of mind. For my
Well, just give me
folks'
one
sake.
moment.
What is unmute?
So what will end up happening is you will be brought back tomorrow at 11 unless there's some medical reason for him not to be brought back. But before he leaves, I would like to have an election.
That was filed, I believe it should be in the court's file, Judge, and we are electing jury
Okay.
for punishment. Additionally, there should be in the court's file an application for probation
Okay.
that was filed with the court. I filed that yesterday.
All right. We'll check and see if all of that information is here. In the
Okay.
meantime, Mr. Lopez, we'll bring you back tomorrow if medically he's allowed to come back.
Okay, and I do have a motion in limine, and I have another motion, Judge, with regard to requesting that the court not transmit the trial.
Mhm.
I did put an order in there. I don't think that you need any more argument from me about it, but you certainly, I would ask you to rule on that motion with regard to our request not to have the trial broadcast on YouTube. And then some of the motion in limine may affect Bourdieu in part, but I'm not certain. I didn't know if since I haven't tried a case with you before, I didn't know if you wanted to do that this afternoon or if you wanted to
No,
go over
have
the
you all-
motions or
have
if
you
you want to do it
conferred?
tomorrow.
With the state on these motions?
Taking a brief look, Judge, if I can just have a second.
So if you all want to confer on the motion in limine, and if we could, we can have Mr. Gonzalez sent back so that they can do the testing and hopefully have that done
Great.
by tomorrow. So we'll send him back. And Mr. Lopez, nothing will be done on the record without your being here. So the motions that your attorney wants heard, will have more than ample time to hear those before the start of trial.
Great, Your Honor. Thank you so much. And then I'll confer with the state's attorney before I leave. And just to be clear, tomorrow I need to be back here at 11 a.m. or should I be here before 11 a.m.?
I only had one thing to sign, and that was his application for community supervision. That's it. So we can find out where it went. All right, Virginia Cerna.
Yes, ma'am. Morning.
Good morning. So what is happening with this case?
Judge, I believe defense has a motion to set off.
Okay.
Yes, Judge, Your Honor, I apologize. I didn't have Ms. Cerna on my schedule this morning, so that's why we're here in the afternoon. However, her original bond for an aggravated assault with a deadly weapon case was $15,000.
Mhm.
It got revoked to without bond because she picked up 3 charges of aggravated robbery back in late October of last year. Finally, last week, the San Antonio Police Department provided the district attorney's office police reports, all kinds of discovery, which I've finally been able to review and seen. I don't know how much we want to get into it here, but we're strongly disputing the facts of the aggravated robbery. So what we're asking the court is to reinstate her bond of $15,000 and her 3 charges of aggravated robbery are listed at $75,000 each. We're going to ask for a reduction of that to $10,000, something she can make. She has been incarcerated for the past
Today back to 2 months.
2 months. Additionally, she has a young 2-year-old child, a child who just had surgery on her ear, nose, and throat because of a cyst going on. She needs to be at home. She's a nursing student. She's getting close to completing her nursing degree. We'd like to get her at least the opportunity to be out on a bond where.
All right, state, are you prepared to proceed on a motion for bond?
I am prepared on the motion to set bond on the underlying charge, Judge. I'm not prepared on the motion to modify or lower the bond on the 3 new aggravated robberies, Judge.
So when would you be ready on those cases?
Maybe a week, Judge. I just didn't really have this. I thought we were going to picking a jury right now instead of.
All right, this is what I'll do. I understand that you've been in jail and you want to proceed. I will bring this back on January 11th. Is that enough time, state?
Yes, ma'am.
All right, so we'll come back on January 11th. Are you available? If not, we can do it on the 16th.
No, I'd like to get it done as soon as possible, Judge. I do have a trial setting the 144th on the 11th, but if we can do it sooner in the morning versus later.
Oh,
I'd be
yeah,
happy to
if you're
do it.
at 9 a.m., we'll take it up at 9 a.m.
Sounds good.
Thank you. Ms.
Yes.
And Judge, for terms of preparing, are you looking to see facts and circumstances of the new aggravated robbery cases?
I mean, if you all want to present police reports for me, then I'd be willing to view those since it's a bond reduction. Hearsay is allowed, so I'll be prepared to look at those.
We'll get to that.
All right, so we'll come back on Thursday at 9 a.m. I would put you on Wednesday, but Wednesday, we're going to be doing jury selection as well as going into testimony. So the 11th at 9 a.m. will be the availability that the court has.
Thank you so much.
a young nursing student, a 2-year-old child fresh out of surgery, and 3 new aggravated robbery charges. Her first case was aggravated assault with a deadly weapon, bond $15,000. After the robberies, that bond was yanked and the new bond set at $75,000 each. Now her lawyer says the police got it wrong, she's been in jail 2 months, and she deserves to go home on a lower bond. Would you let her out while these charges are pending? Hit like, share this clip, and drop your verdict in the comments.